Good afternoon, everyone. My name is Gerald Maatman, and I serve as the chair of the Duane Morris Workplace Class Action Group. I'm a part-time professor of law at Northwestern University, where for the last 35 years I've taught trial advocacy. I'm also the author of our firm's flagship publication, the Class Action Review, which is now in its 20th year, and I'm the editor and author of the ALM book on class actions in all 50 states. We're going to give some people some time to join the show because we still have people logging in. And while we wait, I wanted to give you a few details about our in-person conference that we're hosting next month. I'll be co-chairing the 8th annual Class Action Money and Ethics Conference along with my colleague, Jennifer Riley of Duane Morris. The event is Monday, May 6th at the Harmony Club in New York City. We have a great agenda this year, and we hope to see you all there. We'll go ahead and post a link in the chat to the conference website so everyone can take a look at the particulars. Well, we're about ready to get started, and I wanted to quickly thank our sponsors and to share a conference discount code for the attendees of the webinar today. You can register with our discount webinar code 24, all in lowercase, to receive a 20% discount off your conference ticket. The promotion is only valid through midnight tonight, so don't wait so long. So without further ado, I'm honored to present our first panel of the day, The Rise in Artificial Intelligence in Class Action Litigation, brought to us by Baldo, Vinti, Jeff Warshafsky, and Jennifer Yang from the Proskauer Rose firm. With that, I'll go ahead and pass the baton over to our speakers.
Good afternoon, everyone. My name is Baldo Vinti. I am a partner at Proskauer Rose here in New York City. I head the IP group. And today we're going to be talking about the rise in AI class action litigation. And with me are my two colleagues, Jeff Warshafsky and Jen Yang, and they will introduce themselves.
Sure. I'm Jeff Warshafsky, also a partner here in Proskauer's New York office. I do a lot of class action litigation, which ranges from various subjects, including false advertising, privacy litigation, and now in this new world, AI class actions.
Hi, everyone. I'm Jen Yang. I'm senior counsel here, also in the New York office. I work with Jeff and Baldo on class actions on a pretty much daily basis. Similarly, doing false advertising, privacy, and AI as it's expanding in the space.
All right, I'm going to put up our deck here.
As everyone probably knows by now, generative AI, or known as Gen AI, is a form of AI that can create text, images, computer coding, music, you name it. And in order to get these results, the algorithm is trained through base level of information and generally off some content that the creator or the engineer provides. And then the algorithm learns how to further refine its outputs based on the interactions with users. Public use for generative AI has increased exponentially since at least for the last few years, at least to lay consumers. And as more generative AI systems are released for public use, questions arise, right? And the type of questions that we're seeing are: what are the promises? What are the threats? What can organizations do to protect themselves against what they're seeing in the marketplace, which are a number of lawsuits, specifically class action lawsuits. Class action lawsuits have proliferated in this context for a number of years, and the cases are only getting bigger, and the plaintiffs are even getting more aggressive as the Gen AI is really taking hold of our everyday lives. And so we're going to talk about a number of issues today. One of the issues we're going to be talking about is issues surrounding the development of the generative AI systems, including the legality of the data collection used in training these systems. And Jeff's going to talk a lot about that in the context of the copyright cases. But we've also seen a lot of other types of class actions in the public use, the privacy, biometric space, and the class actions here, they're demanding that the AI companies or users, such as their partners who use this information, pay for the data that they've used to train their models, or even stop using the algorithms altogether, as we see in some of the privacy class actions. So if we go to the next slide, here's just a snapshot of what we're seeing in the last year or so. You're really seeing an increase in the number of AI cases. As you could see from the slide, industry giants such as Microsoft, Google, Meta have all been named as defendants in suits, alleging, among other things, copyright infringement, invasion of privacy, and unfair competition. It's not just these giants, right? They're also companies that solely work in the AI space, such as OpenAI, Stability AI, Anthropic. They've all had class action suits against them for their alleged use of copyrighted materials to train the Gen AI models. And briefly, I'm sure a lot of folks are familiar with the type of AI that's at issue here. Let's start with ChatGPT. By now, most people have become familiar with ChatGPT. It's OpenAI's free use to generative AI system. It's capable of completing tasks such as answering research questions, composing essays, or engaging in human-like conversation. We've all heard the stories about folks trying to use it everywhere from writing a term paper to doing legal research on it. Obviously, there are a lot of concerns with when you're using this software. And we've seen decisions coming out where folks have used it for legal research, and the Gen AI has been hallucinating, for example, and providing cases that don't exist. But as the technology improves, we expect that the accuracy of these models to also improve. Another commonly used program is Copilot. It's another AI tool. It's touted as your everyday AI companion. The aim here is for it to act more as a personal assistant. It's been used in Microsoft's 360 programs. And again, it could create, fix computer code. It could create PowerPoint presentations, Word documents, or other formats. So this is another one that's being targeted, especially by the plaintiff's bar. Gemini is another tool. And it's Google's version or Google's answer to ChatGPT and Copilot. It's also intended to replicate human-like interactions, and you could use it just like you do with ChatGPT, where you ask the system to please explain or help me brainstorm on why, and you'd get some sort of response. While it's also capable of creating content, Google had to pause it in 2024 because it was receiving some criticisms and backlash over its depiction of historical groups. So that's something obviously that's being worked on. And then there are obviously a number of other platforms, and one that's on the screen is Stability AI. We've seen that one, but there's a number of other platforms such as LLAMA, which is which stands for Large Language Model Meta AI, and that's from Meta. It's really intended to help researchers who don't have access to large language models and the type of infrastructure that's needed to work with those LLMs. So if we go to the next slide, what we see here are a growing number of states have really moved to regulate AI-related conduct. And so here we have we're showing the states that are targeting deep fakes from Gen AI algorithms, but there are other states that are concerned with other issues. For example, some states are concerned with the perceived notion of job losses relating to Gen AI systems. Others are addressing how the advancing AI technologies will impact a person's image, likeness, personhood. So for example, Texas and California have passed bills regulating the use of Gen AI in election campaigns. That's been something that's been the focus, especially in this election year. New York has regulated deepfakes using the likeness of performers and famous personalities. Idaho and North Dakota have passed bills making clear that AI is not granted personhood under the state's existing laws. The autonomous vehicle industry has drawn a fair amount of scrutiny. States like Delaware, Massachusetts, Ohio, Arizona, Idaho, and Hawaii have passed laws regulating the AI and autonomous vehicles that use that AI. What we're seeing is generally all states have focused on this in one form or another. And we've seen governors from numerous states issuing executive orders regulating the technology, even in the absence of state regulations or actions. And so, as we're going to discuss in this presentation, states are beginning to take action against AI collections, such as biometric data, and also using consumer privacy laws to target AI. And what this means also with these regulations, with these, with the executive orders, is actually a rise in class action litigations. And the plaintiff's bar is focused on this. We've talked to a number of plaintiff's lawyers. We've seen what they've said. We're mostly on the defense side, or we're always on the defense side here. And what we've seen is really AI related litigation becoming a focus of the plaintiff's bar. And we only expect it to increase in the years to come. And it's something that we're focused on. We have cross disciplinary group that we work with folks in not just in class action litigations, but we bring in our privacy experts, we bring in our technology experts, and we bring in folks that have expertise with government bodies and in all sorts of areas, including antitrust and other areas. So this is a focus for our group. It's a focus for our firm, and we are seeing a lot of activity in this space. So with that, I will turn it over to Jeff Warshafsky to talk about copyright infringement and involving AI.
Sure. So one of the main areas we're seeing class actions relating to AI is copyright infringement. And the reason is that, as Baldo mentioned, AI engines require substantial data to be trained, and sometimes, or very often, that data may be copyrighted. So the classes at the heart of these new class actions are summarized here, and they basically consist of content creators who are concerned about Gen AI's use and replication of their copyrighted works. A large portion of these cases have been brought by authors, for example, actress and author Sarah Silverman, who accuse Gen AI companies of wrongfully using their copyrighted works to train the algorithms. Other classes are made up of television and playwriters, journalists, musicians, artists, et cetera, and they all share the same concerns. And basically, their complaints are alleging copyright infringement, other causes of action that we'll talk about as well, and are expressing damages based on a theory of not just infringement, but also that they're using their works or replicating their works to potentially make the artists or authors' jobs obsolete in a few years' time. So several of these cases have been brought against OpenAI, and those have been consolidated for the most part in the Northern District of California. The first case was brought by novelist Paul Tremblay. I mentioned Sarah Silverman, who brought another such lawsuit, and there's several others. They've been consolidated together. The plaintiffs allege copyright infringement, various forms, including direct, vicarious, and contributory liability. They allege DMCA violations. I'll explain that a little more. And then they also allege various state law violations, including California's unfair competition law, negligence, and unjust enrichment. Similar to what I was saying, just being more specific here, basically the plaintiffs are alleging that OpenAI trained its ChatGPT large language models, including ChatGPT 3.5 and 4, with literary works that were still under copyright without the authorization of the owners. The DMCA violations are predicated based on allegations that in doing so, as part of the training process, OpenAI removed copyright management information associated with the works. So in August 2023, the defendants moved to dismiss, and earlier this year in February, we received a decision that granted in part and denied in part the motion to dismiss, largely granted it. The plaintiffs alleged that every output of ChatGPT was an infringing derivative work. And in dismissing the plaintiffs' claims for vicarious copyright infringement, the court found that allegation insufficient because the plaintiffs had failed to explain how the outputs were substantially similar or similar at all to their books. The court also dismissed the DMCA claims and found that the plaintiffs had failed to plausibly allege that OpenAI had intentionally removed or altered any of the copyright management information, such as the titles of their works, the authors' names, or other identifying information. And the court further noted that even if the plaintiffs had shown that OpenAI had intentionally omitted that information, the plaintiffs had still failed to plausibly allege that OpenAI did so knowing that the outputs from ChatGPT would induce, enable, facilitate, or conceal infringement. And then the court also found that the plaintiffs had failed to allege that OpenAI had distributed the plaintiffs' books or copies of their books. As I mentioned, the plaintiffs also sued under California law, specifically California's unfair competition law, or the UCL, and the court mostly dismissed those claims. It found that the plaintiffs' claims for injury were speculative and that the plaintiffs had failed to meet the heightened standard for bringing a claim under the UCL's fraud prong, but the court did find that the plaintiffs could proceed with their UCL claim for unfair practices, which isn't subject to Rule 9b, assuming that their allegations of direct infringement were true. As to the negligence claims, the court dismissed them for failure to show that the plaintiffs owed them a legal duty, and then the court also dismissed the plaintiffs' unjust enrichment claims for failure to allege that the defendants unjustly obtained benefits from the plaintiffs' copyrighted works through fraud, mistake, or coercion. The court did grant leave to amend, and the plaintiffs amended their complaint about a month ago, and they greatly slimmed down their claims. They're now only alleging direct copyright infringement and unfair competition. So meanwhile, on the East Coast here in New York, OpenAI is defending another case. The Authors Guild sued OpenAI in the Southern District of New York in September of 2023 on behalf of a class of fiction writers. The complaint alleges claims for direct copyright infringement against Microsoft and OpenAI for using the author's copyrighted works of fiction to train their Gen AI models. It also alleges vicarious infringement against Microsoft, OpenAI, and some of their subsidiaries. The plaintiffs are seeking, among other relief, an award of $150,000 per infringed work and an injunction prohibiting defendants from infringing on their works in the future. The defendants filed answers to the consolidated complaint. I'll talk about that in a minute. One thing we wanted to point out is that the plaintiffs from the INRI OpenAI case in California that we just talked about tried to intervene in the New York case or in the alternative to have it dismissed or consolidated and transferred into the Northern District of California action. Earlier this week, this past Monday, the court denied that motion and found that there are substantial differences between the actions that lessen any risk of contradictory rulings. For example, the California plaintiffs assert state law and DMCA claims that are not raised in the Authors Guild case in New York. And Microsoft, which is a defendant in the New York case, is not a defendant in the California action. And more importantly, to the extent there was some overlap in the claims, and for those that did overlap, the court basically found that the California plaintiffs don't have an interest in avoiding a different action in New York because no class has been certified in either case. And so at this point, you have cases brought by a few individual plaintiffs in New York, a few individual plaintiffs in California, and without a class being certified, they're only representing themselves and therefore can't be impaired by a decision of another court where nobody is representing them. So this case will proceed independently from the INRI OpenAI action in California. I mentioned that the defendants answered. Some of their affirmative defenses are notable in thinking about how companies are looking to defend these claims. Both Microsoft and OpenAI claim that any copies of plaintiffs' works constituted fair use. And they also assert the defense of de minimis copying, basically saying that whatever copying did occur was too insubstantial or trivial to qualify as infringement. Another defense that they raise is called scène faire, which is basically the idea that certain concepts or scenes from books or films are obligatory to all works within a genre, and those are not protected under the US copyright laws. So for example, it's very common in spy movies or novels to have spy gadgets, and so you can't copyright that element. And so that's one of the defenses being asserted. And then another is the defense of substantial non-infringing use, where the defendants are claiming that their products, services, and actions in connection to Gen AI models have commercially significant non-infringing uses. So here's another similar case brought by the New York Times. It's not a class action, but it's sort of related to these class actions. Basically, the plaintiffs in the INRI OpenAI class action tried to intervene in this case too, and the court denied that motion on Monday in the same order for the same reasons as in the Authors Guild case. Many of the claims here are similar to those that were raised in the other cases I've talked about, but interestingly, this case also includes allegations of trademark dilution. Basically, the New York Times is alleging that the defendants use their trademarks in outputs from the AI engines, but that those outputs are of lower quality and inaccurate writing, and that this harms the New York Times trademark and causes them damages, including harm to their reputation for accuracy, originality, and quality, and therefore economic loss flowing from all of that. So here's a class action that was filed elsewhere. We're moving away from New York and California. This was filed in the Middle District of Tennessee, and this case involves music. It was filed by a putative class of music publishers who are accusing Anthropic of wrongfully using the publisher's copyrighted lyrics to train its Anthropic's set of Gen AI models called Claude. Basically, the plaintiffs are saying that if you prompt Claude to change the lyrics to famous songs that are within the publisher's musical compositions, for example, American Pie or Sweet Home Alabama, the AI chatbot will provide responses that contain all or at least significant portions of the lyrics from these copyrighted works. So similar to the other cases we've talked about in the in the authoring context, the plaintiffs assert claims for direct, vicarious, contributory copyright infringement, and so on, basically alleging that Anthropic knew or should have known that using the plaintiff's copyrighted works as training data and allowing the AI system to produce outputs that contain lyrics from their songs or are substantially similar to their songs constituted infringement. And then we see the same allegations about DMCA violations for the wrongful removal or alteration of copyright management information in terms of what is output by the models. So in November 2023, the plaintiffs moved for a preliminary injunction, something we hadn't seen in these other cases. And the publishers are claiming that they would suffer irreparable harm if they don't get an injunction because Anthropic's actions are causing harm to their relationships with songwriters, harm to the reputations of the publishers, and are eroding the value of and licensing markets for the copyrighted works. Around the same time, Anthropic moved to dismiss for lack of personal jurisdiction and improper venue and sought for the case to be transferred to California. So they want to join the party over there, but we'll see what happens. Those motions are pending. Currently, a jury trial is set for November 2025, but obviously that could get moved depending on various factors, including the motion to transfer. So here's another case involving AI. Basically, Thomson Reuters alleges that it discovered a spike in its Westlaw searches by a third party whose searches spiked from an average of 6,000 per month to over 230,000 per month. And so they looked at that and they found, allegedly, that the search activity was being performed by bots or automated computer software in violation of Westlaw service agreement. And further, they found that the bots apparently were downloading and storing copyrighted Westlaw content in bulk. What Thomson Reuters alleges is that a competitor or a sort of putative competitor, Ross, was behind this and was using the bots because they're trying to make their own AI legal system. And that in doing so, Ross was violating the copyright laws. Interestingly, Ross asserted counterclaims, including for violation of the antitrust laws, which is something we haven't seen in these other cases, but is an interesting response. The case is now at the summary judgment stage, and we'll keep an eye on this one. So Baldo mentioned some of the image generation AI models. For example, Stability AI. They were sued in this case along with DeviantArt and Midjourney. Basically, these models allow users to input text and then the engine outputs an image. For example, and this is just one of many examples you could conjure up, you could ask it to generate an image of dogs playing poker in the style of Picasso. It's not limited to, in the style of a particular artist. You could do anything, but that's really what's at the heart of this case, because the plaintiffs are a putative class of artists who allege that the defendants infringed on their copyrighted works by using them in the training sets. And then they further allege that the engine's outputs are derivative works of the plaintiff's copyrighted works. The plaintiffs also claim that the system allows users to create images in the style of the artist, and therefore violates the artist's right of publicity, which Jen will talk more about that, but that was an issue in this case. So the defendants all moved to dismiss, and in October of 2023, the court granted the motions to dismiss with leave to amend. The court dismissed the copyright actions of 2 of the 3 named plaintiffs because it found that they had not registered claims of copyright on any of their works. And for the 3rd plaintiff, Anderson, the court limited the claims to those where she had registered claims of copyright. More fundamentally, though, the court found that the plaintiff's theory of direct infringement was lacking. One of the theories the plaintiffs had was that the AI engines directly infringed their works because the engines somehow contained compressed copies of the training images. But the court found that this allegation was too vague to state a claim, and that the plaintiffs had not explained what they meant by compressed copies, where that would reside in the code, and so on. The court also found that the plaintiffs did not plead their DMCA violations with enough specificity, and similarly found that the plaintiffs failed to state a claim for violation of right of publicity because the plaintiffs did not say had the defendants used the plaintiffs' names or likenesses in any of the outputs from the AI engines. So the plaintiffs amended their complaint in November. They added a new defendant. They're making some new allegations relating to copyright infringement, DMCA violations, and also unjust enrichment. They did drop their right of publicity claim, however, and the defendants have moved to dismiss, and that briefing is underway. So the last case we'll talk about on copyright infringement, we wanted to note that it's not only individual artists who are taking use with these tools, and this was another case involving stability. So we're talking about image generation AI. So Getty, which I'm sure everyone's familiar with, Getty has a very large repository of images that you could buy or license. And Getty alleges that Stability AI trained its AI engine called Stable Diffusion on millions of Getty images. And it's not just the images. Getty also claims that there's captions that go with its images and metadata that provide a lot more context to the AI algorithm that it would get from images alone, which makes Getty's content particularly valuable to someone trying to create an AI image generation model such as Stability. So the actual allegations here are fairly similar to the other cases. There are the allegations of copyright infringement, DMCA violations. Interestingly, and this is sort of like the New York Times case, Getty also asserts claims of trademark infringement and dilution. So you can see in this example image, the Getty images name is there, Getty's trademark. And Stability is saying that not only is this confusingly similar use of Getty's trademark, but it's also a dilution because sometimes the images are bizarre or grotesque in Getty's words. And this is perhaps an example of that. And as a result, Getty is alleging that by having the Getty images watermark in the output images from the engine, users and consumers might think that Getty's images are of lower quality, and therefore that dilutes the Getty trademark. So Stability moved to dismiss in May of 2023. It asked the court to either dismiss the action for lack of personal jurisdiction or to transfer it to, you guessed it, California. The court denied that motion without prejudice, but it is allowing some jurisdictional discovery to proceed, and then may allow Stability AI to renew its motion after that.
All right, let's talk about right of publicity. So the right of publicity, of course, protects against misappropriation of a person's name and likeness for commercial purposes. And as Jeff mentioned, we're seeing this in the AI space now, particularly with the rise of deepfakes and AI's ability to create fake content that replicates a person's image and voice in a way that can sometimes be indistinguishable from the real thing. Celebrities and their estates are now looking to state law right of publicity claims to try to protect themselves from these new types of unauthorized uses. So in April of last year, Kylan Young, who is a reality TV celebrity of sorts, he was a cast member in a couple of reality shows such as Big Brother and The Challenge USA, he brought a class action complaint against NeoCortex. So NeoCortex owns the smartphone app Reface, which is a deepfake software that allows users to swap their faces with the faces of actors, musicians, athletes, celebrities, and the like. Young claims that NeoCortex violated California's right of publicity laws by knowingly using his and other putative class members, basically celebrities, names, voices, signatures, photographs, or likeness for the purpose of advertising or selling the Reface app. So Young claims here that NeoCortex is telling prospective customers that they can mix your face with a celebrity, and then they download the Reface app and they select from a catalog of celebrities, including Young. They upload to Reface their own faces, and that creates a teaser face swap, which comes with watermarks. And then to remove those watermarks, users have to pay a subscription fee and upgrade to the pro version. So of course, Young alleges that he never consented to NeoCortex using his image. He's never been compensated for that use. And dissemination of these watermarked face swaps, and then soliciting customers to pay subscription fees to upgrade to the pro version and remove that watermark, is a commercial exploitation of his and other class members' identities in violation of the right of publicity. So NeoCortex moved to dismiss and also moved to strike under California's anti-SLAPP statute, which allows defendants to strike actions that are intended to deter people from exercising their political or legal rights or punish them from doing so. So the court really focused on the anti-SLAPP analysis, which in a lot of ways subsumes the motion to dismiss. The first step of that analysis looked at whether NeoCortex use of Young's image was made in furtherance of NeoCortex right of petition or free speech in connection with a public issue. And there the court actually agreed with NeoCortex that because celebrities take on personal meanings to many individuals, creative appropriation of celebrity images can be an important avenue of individual expression. So wrongful or not, the court said, NeoCortex use of Young's image gives users a tool for that kind of expression and therefore is conduct in furtherance of users' free speech rights. And because Young is in the public eye, and because the use of technology to alter images and videos in a way that makes them look realistic is a topic of widespread public interest, the court said NeoCortex had shown that its conduct here was in furtherance of the right of free speech and made in connection with the public issue. But then, of course, we get to the second step of the anti-SLAPP analysis, and that looks at whether the plaintiff can show a probability of prevailing on the claim. So NeoCortex made three arguments here for why Young supposedly failed to make that showing. And just to put the lead up front, the court rejected all three. So first, NeoCortex argued that Young's right of publicity claim was preempted by the Copyright Act. So basically, things that fall within the scope of copyright law are preempted. But the court here said that while the Copyright Act protects ownership of photographs, it does not protect the exploitation of one's likeness, even if that is embodied in a photograph. So here, because Young's allegations were really about how his name and likeness were used, the complaint did not fall under the subject matter of copyright laws and therefore was not preempted. Second, NeoCortex argued that the claim was barred by the First Amendment. So one affirmative defense under California law to a right of publicity claim is that the work is protected by the First Amendment because it contains significant transformative elements, or the value of the work does not derive primarily from the celebrity's fame. So NeoCortex basically said this squarely applies here, since the entire purpose of this app is to transform a photo or video into one where the celebrity's face does not actually appear anymore and is replaced by the users. But the court said, no, the celebrity's face is the only thing here that's changing. And at least in some instances, the end photo still depicts the celebrity's body. So that wasn't a sufficient basis to show that the plaintiff was not likely to prevail. And then finally, NeoCortex argued that Young had not made a prima facie showing that NeoCortex violated Young's right of publicity. So the first element of a California right of publicity claim is that defendant knowingly used plaintiff's identity. And NeoCortex argued that the plaintiff here failed to establish that because the app was scraping video clips of celebrities and then indexing them in its database, as opposed to, for example, the developers going out and finding photos and videos themselves. And Young argued that NeoCortex acted knowingly by programming an app that did the scraping. So the court here agreed with Young, said NeoCortex did not provide support for its assertion that knowingly here means affirmative knowledge of the presence of Young's and other celebrities' images in their app. So construing the complaint in the light most favorable to Young, the court said Young had adequately pled that Neocortex here had knowingly used his identity. There is an appeal. So Neocortex is appealing this decision to the Ninth Circuit, and the case has stayed until the resolution of the appeal. So we'll be watching out for that. All right, so this is another case alleging that Gen AI created celebrity content, violated plaintiff's right of publicity. This one is not a class action, but you can sort of imagine the same theory being alleged here if more celebrities were implicated. So George Carlin was an actor and comedian. He passed away in 2008. In January of this year, the podcast Dudesy promoted an AI-generated picture of George Carlin alongside a caption, "Tomorrow, call me Dudesy." The next day, there was a podcast episode in which hosts watched and listened to an AI-generated George Carlin special and then discussed how the special sounded just like him. And then Dudesy released the full-length special called George Carlin, I'm Glad I'm Dead, 2024, on its YouTube channel, and also included links to its apparel shop in the video description. So the video, of course, used an AI-generated sound-alike to read out and perform an AI-generated script that was written in Carlin's style of humor. Carlin's estate saw this and filed this lawsuit against Dudesy and its hosts, alleging that using Carlin's likeness without authorization to draw attention to Dudesy's show and merchandise was a violation of Carlin's right of publicity. And in addition, as Jeff had discussed, Carlin's estate actually also alleged here that Carlin's copyrighted works, the use of Carlin's copyrighted works as training data for the creation of the script constituted copyright infringement. So we will never know how this case would have come out. Just yesterday, actually, the parties submitted a stipulated consent judgment, which provides that defendants will be permanently enjoined from posting the Carlin special and from using Carlin's image, voice, or likeness on their podcast or any other platform that they control without prior written approval. But it is just a good warning as to the sorts of issues to watch out for in creating this type of content. Okay, so turning to defamation. So Baldo described AI hallucination. You ask ChatGPT a question, it gives you a fictitious answer. These pose a host of issues, including potentially legal ones. The defamation cases that we've seen so far in this space have not been class actions, but again, you can theoretically imagine the claims translating over, although I will say that in defamation, it might be harder to get to class certification. All right, so let's talk about Walters v. OpenAI. So here, plaintiff's friend was a journalist who was using ChatGPT in connection with a lawsuit that he was reporting on. So he provided ChatGPT with a link to the complaint for that lawsuit and asked for a summary of the allegations. And in response, ChatGPT told him that it was a complaint filed against the plaintiff in this case, and that this plaintiff was being accused of embezzlement. That was wrong. The plaintiff here was not a party to that lawsuit, but the plaintiff's friend then asked ChatGPT to provide him with a copy of the complaint. It did, and according to the plaintiff here, the entire complaint that ChatGPT produced was a complete fabrication, including the allegations against the plaintiff. So plaintiff sued for defamation. OpenAI moved to dismiss on a number of grounds. For example, it pointed to disclaimers on ChatGPT's site that addressed the potential for the program to generate false or inaccurate information. It also pointed to its terms of service that said users should verify its outputs and take ultimate responsibility for the content that they decide to use and publish from ChatGPT. And OpenAI also argued here that no defamation occurred because given the fact that plaintiff's friend was the one who entered the content parameters in the first place, clearly knew what the lawsuit at issue was, he couldn't have believed that the content produced was accurate or truthful. Earlier this year, a Georgia state court did deny that motion. It was a short one-paragraph opinion, so we don't really have the rationale behind it, but that case will move forward. Just briefly on this next one. So this was a pro se complaint filed against Microsoft. So plaintiff here, his name was Jeffrey, F-F-E-R-Y, Battle. And he alleges that Bing Chat, which is an AI-powered chat software developed by Microsoft, conflated him with Jeffrey, R-E-Y, Leon Battle, who was a convicted terrorist. So a plaintiff says when responding to certain content inquiries, Bing Chat basically intertwined the plaintiff's life story with Jeffrey Leon Battle's life story. And according to plaintiff, unlike OpenAI, Bing Chat fails to actually disclaim the veracity of its content generation, and instead actually says that The summary was generated using AI based on multiple online sources. To view the original source information, use the learn more links, which might actually suggest that this is based on something factual. So plaintiff further alleged that he reached out to Bing to take down the posts and that Bing did so, but then the same content kept being reposted soon after. No substantive motions have been filed in this case to date, although based on some of plaintiff's filings, it looks like Microsoft may be trying to move to compel arbitration, but we're going to be keeping an eye out on this one too.
Great. So now we'll turn briefly to some of the privacy and breach of contract and related cases that we're seeing with AI. So the first one is with AI and biometric data. You know, the rise of biometric authentication has led many states to start addressing the collection and use of the biometric data. While not all biometric capture uses AI, the advancements in AI have really transformed the capture and the use of the biometric data. So for example, AI can help with facial recognition by analyzing facial features and matching them with various databases. AI algorithms can also enhance the speed of which biometric identification happens, the verification process as well, the speed of that. And it enables real-time analysis and authentication. It reduces the authentication time to really seconds. And so with the rise of these AI tools that can quickly collect, store, and synthesize the information, what that means is that the legislatures are trying to really pick up their pace in implementing laws and to match with the rise and the capabilities of the AI. And so what we're seeing is a great deal of class actions filed in this space, alleging violations of privacy laws, especially. And the argument there is that data was collected without the knowledge and consent. So if we go to the next slide, we'll see that legislatures have been focused on this for well over a decade, and they've been focused on really biometric data gathering, even pre rise of the Gen AI being used for biometric data capture. But now, like I said earlier, with these tools being more readily available and really kind of increasing the use and expanding the use of it, we're seeing much more class actions in this space. And so what the legislatures are trying to do is they're trying to really get a handle and force some sort of consent. And so one of the earliest laws that we've seen is the Illinois Data Privacy Law, right? Under which a number of class actions have been filed. And it's BIPA is the name of the law. It's Biometric Information Privacy Act. And under this law, since 2015, we've seen well over 2,000 class actions. The BIPA, unlike some other privacy or biometric laws, does include a private right of action and also includes statutory damages provisions. So these provisions allow plaintiffs to recover $1,000 for each BIPA violation and $5,000 for each intentional or reckless BIP violation. So in passing the BIPA, the Illinois legislature asserted that biometrics are different, right, than other unique identifiers that are used sometimes to access finances or other sensitive information. And the example that's given is, unlike sensitive information such as your social security number, which can be changed, biometrics are biologically unique to each individual. And once compromised, the individual has no real recourse or is at a high or heightened state for risk of identity theft, and so very little options in terms of how to stop this is what the plaintiffs and the legislature has kind of pointed to. Other states have passed biometric laws as well. So, for example, Texas passed the Capture or Use Biometrics Identifiers Act. That was passed in 2009, which applies to all private entities in Texas, except for financial institutions and their affiliates when retaining voice print data. There's a whole list of requirements that businesses have to do to obtain consent, and it also imposes a 1-year limit on the biometric data retention. So again, as with the BIPA, class actions, plaintiff's bar has really tried to expand what the intent of this law is, and they're making some of the same arguments that I mentioned earlier, arguments such as once this data has been identified and captured, the plaintiff has no recourse. Of course, the defense bar has answers to that. And so the Texas CUBI was supplemented in last year by the Texas Data Privacy and Security Act. This law generally establishes a framework for disclosure requirements relating to both the collection and the retention and the processing of such data. It grants consumers rights in their data and mandates the ability to have the consumers opt out of specific data processing activity. It also imposes obligations on data controllers and processors. So unlike the BIPA, there's still no private right of private cause of action under the TDPSA or the CUBI, which were both passed by Texas. So we've mentioned biometric data. We've talked about legislatures trying to curb the use of this without informed consent. So what exactly counts as biometric data? Well, the legislatures, as you can imagine, have really tried to define this broadly. So we focus on the BIPA. The two of the terms that are used, primary terms that are used, are biometric information and biometric identifiers. So biometric information, that means any information, regardless of how it was captured, converted, stored, or shared based on an individual biometric identifier used to identify an individual. So what is an individual's biometric identifier? Well, the court defines that, not the court, the legislature defines that as well. Biometric identifier means a retina or iris scan, fingerprint, voice print, or a scan of a hand or face geometry. So notably, biometric identifiers do not include writing samples, written signatures, photographs, human biological samples used for valid scientific testing or screening, demographic data, tattoo descriptions, physical descriptions such as height, hair color, or eye color. So importantly, biometric information does not include information derived from these items or procedures that are derived from these items. So if you fall in one of the exceptions, that gives you a good basis for arguing that the information is not biometric information. Texas's CUBIA Act is similar to the BIPA in that it covers the collection of retina or iris scan, fingerprints, voice prints, or record of a hand or face geometry. And so Washington State also has defined this, but they've got even broader. And so you could see that in the data, My Health Data Act, which was passed in 2023. It also includes, but it goes beyond what Texas and Illinois have stated. So it talks about imagery of the iris, retina, fingerprint, face, hand, palm, vein patterns, voice recognitions, and then it even goes further to say keystroke patterns or rhythms and gait patterns or rhythms that contain identifying information. So really, they're pretty broad, and so this is something that has been the focus of these cases and class actions in particular. What we've seen, we've seen a number of class actions being filed. While we don't have a slide for this particular case that I'm going to talk about, we've seen cases stemming from AI voice assistants that utilize machine learning to to interpret and understand the individual's voice interactions. So basically what these companies are using, companies that use AI voice assistants in lieu of human employees, they're getting targeted, right? And so here the AI captures the unique features of a customer's voice, such as pitch, volume, duration, and plaintiffs are filing these class actions alleging that that this capture violates biometric laws, and including the BIPA. And so what the thrust of these cases is that this information is being stored, disclosed, disseminated without the user's consent. And so here the courts, again, it's very preliminary right now. What we've seen are decisions, but not substantive, outside the context of a motion to dismiss, for example, whereas as we all know, in the motion to dismiss, the allegations are given, a favorable view into, because there hasn't been any fact discovery yet. So courts look at, for example, what is the data that's being captured, and they're looking at it as, is it really speech to meaning, which is something the courts focus on, which is defined as technology that analyzes speech signals in real time to obtain a result. So there you're capturing the information to obtain a result. They're contrasting that with, for example, with speech to text technology, which is simply, what we have on our iPhones, which transcribes the voice interactions to usable transcriptions. And so, while there's been some decisions on a motion to dismiss, nothing has been established in terms of substantive law. And this is an area that we're involved in, and we're tracking, obviously, because it's important to our clients. Some of the other cases that we're seeing is the one here, which was filed, about a month or so ago. And this is a punitive class action alleging that OpenAI used stolen private information from hundreds of millions of internet users without informed consent or knowledge. And so again, these are the, what I just read is the quote from the complaint. Plaintiffs allege that while OpenAI scraped the public data, it's the aggregation or the collection of information that reveals new facts about the person that person would not have expected, right? So they're saying, like, in essence, that the public information that's out there, if you look at it in isolation, it's not all that damning, right? But when you take it and compile it and put together the information in a way that provides some sort of result, some sort of pattern, or some sort of new information about the person, that's a violation of some of the privacy laws and requires consent. That's the argument that's being made. And so, here the complaint spans about 114 pages. And just to give you a flavor of the type of counts that are being asserted, there's 4 allegations regarding statutory and common law privacy rights, 1 count of fraud, 1 count of violation of California's unfair competition law, and then we have 4 counts related to common law property rights, including larceny, conversion, and unjust enrichment. So again, here the allegations is that the users expect many people to view their posts, but don't expect that this information would provide an aggregate picture. And in fact, the complaint says that folks that post publicly, they expect that some or all of this information will remain basically private, in the sense that it'll be ignored, right? So there's many posts, there's much information, but without it being put all together, it's just going to get ignored because there's so much noise on the internet. It's only when this data is really compiled to provide a result that there is an invasion of privacy, at least according to the allegations of the complaint. So this is obviously something that we're going to keep an eye on, and we've had a number of clients reach out to us about this and implement or help them implement ways to avoid some of these class actions. Another case that I'll quickly talk about is a case that's been pending for a number of years. It's the In re Google Assistant privacy litigation. Plaintiffs here sued Google under the California Invasion of Privacy Act, the California Consumer Legal Remedies Act, and California's Unfair Competition Law. And if you do business in California, you're very familiar with the latter two acts that I mentioned, because these are the kind of catch-alls that the plaintiff bar likes to assert. Here, plaintiffs allege that they brought a Google device that carries the Google Assistant software, and obviously the software is pre-installed, and what it does is it's an AI-based voice recognition software that uses and listens to keywords or hot words. So if you say something like "Hey Google," it'll start transcribing that and listening for that. It's only supposed to record and transmit audio if a hot word is used. The plaintiffs allege that Google recorded and transcribed conversations without their consent on multiple occasions, including when the hot words were not used. And so they brought a class action there. There the court decided the motion to dismiss and granted it on substantially all claims without with some leave to amend there. And so their plaintiffs then filed a second, a third, and a fourth amended complaint. And that case is it's still ongoing. And quickly, while we have a few minutes left, I think we have 2 minutes left. I'll quickly go through some other claims here. I'll just touch on them. There are a number of cases: breach of contract case, due process claims, cases, all involving the use of generative AI. So the first one is a case that was brought in December of last year. It's a breach of contract case. Plaintiffs claim that Humana uses the AI program in lieu of doctor reviews. The AI model allegedly overruled doctor determination on medically necessary care, and the plaintiffs allege that Humana knew that this AI model were highly inaccurate, but they used it in any event to deny coverage. The grounds are that they're using this they're using the AI, and Humana fails to adjust for a patient's individual circumstances, and so they allege 26 causes of action and a number of other actions. A motion to dismiss was filed in March of 2024, so just a few weeks ago, and we're waiting for a decision there. And we'll follow that case. And a number of other cases that we've seen, similar cases against Cigna. There they allege that Cigna developed AI to automatically deny payments in batches, and that it's arbitrary and it doesn't meet certain criteria. And again, here, a motion to dismiss has been filed, and we'll track to see what happens here. And then the next slide, without getting into much detail here, this is a due process claim. Again, the claim here is that the alleged use of AI to detect and adjudicate fraud without human intervention constituted an unlawful seizure of property without due process. So this case was filed a few years ago, and then in January of this year, after the motion to dismiss was denied, the party settled for $20 million. And so you could see that there is a lot of risk in these type of litigations, big money judgments. And so it's important for folks to look at their systems, especially when they're employing AI, holistically look at them for many different type of claims, but including, these type of privacy claims, lack of consent, claims, which are obviously important to get ahead of. So with that, we conclude our presentation. If you have any questions, the first slide here has our contact information. Feel free to email us or reach out to us, online, and we're happy to address any questions and talk about this, because this is something we're dealing with on a daily basis and advising a lot of clients on. Thank you.
Well, that was a great presentation. Thank you so much, Baldo, Jeff, and Jennifer, for sharing your thought leadership and your ideas on this new and exciting area of class action litigation. For some of you that may have joined late, I just wanted to remind you of our in-person class action money and ethics conference that we're hosting in New York City on Monday, May 6th. You can register today with the discount code webinar24 and get a 20% discount off your conference registration. The promotion is only good through midnight tonight, and we'll go ahead and post the links and the discount code to the chat feature on this site. I'm looking forward to our second panel, entitled A Behind the Scenes Look at the Latest Crypto Class Action Cases, featuring Laura Humphries from Buchanan, Candace Smith from Herman Jones, and Will Etchison from the Beard Group as our moderator. I'll go ahead and pass the microphone over to you, Will. Thanks so much.
Thank you, Jerry, for that introduction. Hi, everyone. My name is Will Etchison. I'm the conference producer for Beard Group, and I'm here today with Candace Smith from Herman Jones, and also Lauren Humphries from Buchanan. Lauren and Candace, how are you doing today?
Hey, good.
We're good. Good to see you, Will.
Great. Awesome. Well, it's great to have you here. Just want to note for everyone tuning in today that if they have any questions, feel free to put them into the chat, and we'll try to answer them actively as we continue the discussion. So without further ado, we can go ahead and get started. Lauren, we can start with you. I'd love if you could just give the audience a real quick background on your professional history and also your experience in your recent crypto cases.
Absolutely. I'm a Tampa litigator, Florida girl through and through. I started my litigation practice really representing manufacturers in large-scale toxic tort actions, and now I have moved into the class action space and consider myself, just a commercial litigator here in Florida. I really became involved in crypto not in the context of litigation. It was just because of interest. I had a friend, it was around 2018, and he had a Coinbase account. He was very interested in the technology. He had some friends that were into coding, and just, found it to be something that he wanted to talk about, and it piqued my interest as well. Fast forward about 3 years after that, through my work at Buchanan, Ingersol, and Rooney, which is my law firm, I came to represent a cryptocurrency exchange, a small one that had a token. And they had some litigation that they were dealing with in the state of Florida, litigation involving, the securities issues that we're seeing all across the country now. In representing this client, I decided that, I needed to become as knowledgeable as possible about this technology, not only from an interest standpoint, but from a legal standpoint. And that led me to really spearhead efforts to educate others on cryptocurrency and blockchain. I'm part of my firm's digital assets and blockchain practice group. Currently, I serve as lead counsel for one of the media defendants in the FTX litigation that's pending in the Southern District of Florida. I'll be at Consensus this year. I'll be at Bitcoin this year. I do presentations just on the technology, and I really appreciate the time and the education that you all are giving us as far as the class action space for cryptocurrency.
Awesome. Thank you so much, Lauren. Candace, would you like to share a similar background?
Absolutely. It sounds like we've got two Southerners, because I am from Atlanta. I work in Atlanta at Herman Jones in our Atlanta office. Went to Brown and Harvard, and then came back here. I started a large law firm doing a lot of commercial litigation, all across the gamut, and had a specialty in banking litigation and bankruptcy litigation. A lot of debtor-creditor work in both spaces. And my current practice is antitrust, intellectual property, and a lot of class actions, shareholder suits, data breach, data privacy, and cryptocurrency. I came to the cryptocurrency space a little differently than Lauren. We had a client who had lost assets on a large cryptocurrency platform. They just sort of vanished. And what was a small problem turned out to be a problem that a lot of people had. And we had a class action. And I did not have the years-long runway that Lauren had. So I spent a lot of time on YouTube learning about, what is a token? Because I had heard of Bitcoin during the pandemic, but I had no idea about anything about the space. So I got I won't say I got very knowledgeable, but I got much more versant in cryptocurrency, NFTs, the big coins, Bitcoin, Ethereum, staking, learned all the buzzwords, and also got a better understanding of how those things intersected with my practice. I'm one of the founding members of our cryptocurrency practice, and we currently have cases involving non-fungible tokens, cryptocurrency asset theft, data privacy, and fraud.
Great. Okay. Well, it's great to have you on the webinar today, Candace. You as well, Lauren. And Candace, you had mentioned that there's quite a few terms that are thrown around in the crypto space. There are new terms or terms that are not used in other areas of finance. And Lauren, you had mentioned to me the other day that you had actually had the opportunity to provide Crypto 101 crash courses to colleagues, etc. Lauren, would you mind sharing some of that information with our audience today to kind of get everyone up to speed on what are some of these common terms that are thrown around, as well as what are some of the common processes that we see in the crypto space, and kind of how this thing works?
Yeah, no, absolutely. And how this thing works, we'll have to have, a 101, a 102, and a 103 to get to the end of that. And there are a lot of resources on YouTube, as Candace said as well. But yes, I'm happy to talk a little bit about some of the terms, and Candace mentioned a few good ones. One of the things that I always find interesting, is the word cryptocurrency. How did they even get that word? Well, it's from cryptography. It's the art of writing and solving codes. I mean, this is a technology where you can buy and sell goods or use it as a store of value. And the way that this technology is tracked is by an online ledger of transactions. We know that technology as blockchain. You'll hear the word tokens, as Candace said. You'll hear the word coins or coin. And those are important because what this technology is, as far as cryptocurrency, it's a decentralized currency. And what that means is that there's no bank, there's no government, there's no third party beyond the individual validators, which are across, the network as a whole, that are giving the authority to this currency. And that's why you often hear that, cryptocurrency is kind of the currency of the people, because it's not a currency that's, backed by gold, or it's not a currency that's initiated by a government, and there's no regulatory bank that is giving it its authority. I also heard Candace mention NFT. I think she said non-fungible token. You hear a lot about those in the news. You hear about celebrities promoting or buying those. What an NFT is, if it's a one-of-a-kind asset that represents a real-world object like art, music, game, videos, tweets. I don't know if you saw, in the news when, NFTs were really at their peak, that the first tweet that was ever on Twitter, back when X was Twitter, was auctioned off as an NFT. There's also, many times where actual, sport videos are made into NFTs where people can capture something in time that's not necessarily the image stamp. They were not dealing with, the rights of the photography of the image. We're dealing with the actual one-of-a-kind asset itself. And that's a little bit hard to understand, which, so much of this technology is novel and new. You kind of have to live it for a little bit to truly understand all the different facets that go into it. One of the other terms that Candace mentioned that I think is pertinent, since we're dealing with class action litigation, we're talking about litigation here, is an ICO, which is an initial coin offering. You hear IPOs, you understand what, public offerings are. Well, an ICO, it doesn't necessarily mean that it's a public offering, but this is an offering where investors are selling a token in order to do seed funding, in order to raise money, in order to promote the cryptocurrency that they have created. And we know that when cryptocurrency, really started to take off, I mean, while it's been around for over a decade, in 2017, there was a lot of widespread fraud in ICOs. There were a lot of individuals who were promoting tokens that, really didn't have a valid basis or had such a volume that they were never going to be, of any real value to the individuals that put money into them. And that's, kind of where it started as far as, this prolific, what's real, what's not, as far as the individuals behind these different cryptocurrencies, because there's tens of thousands of cryptocurrencies. And we hear a lot about the big ones, and obviously Bitcoin is in the news, and there's a, tracker on Bloomberg for it. But there's a lot of other coins out there, and, there's a lot of investors that are behind those. So those are some terms that I think are helpful as you go through the crypto space. It's important to understand, a cryptocurrency exchange, like a Coinbase, someone that is able to provide the ability to purchase these cryptocurrencies, often on a platform where you have kind of a hot wallet, a wallet you're able to, move stuff in and out of very quickly. A lot of crypto enthusiasts and people that really live crypto, they're all about the cold wallets, which are wallets that are really, your money behind your stone, as far as technology. It's just you. And that's, once again, going back to, we're not dealing with a bank. We're not dealing with a third party. We're not dealing with a government. We're dealing with a currency that's powered by technology.
Awesome. Thank you so much, Lauren, for that background information. It's very helpful for the people watching, and also for me. Crypto seems to be quite a mystery. A lot of ins and outs in the crypto world. I'd like to ask Candace a question here, because I'm curious about who the types of people are that get involved in crypto, in terms of the victimization, in terms of the people that are actually committing the fraud. Can you tell me a bit about who the people are involved on each side of the table, as well as, what are the motivations involved?
Absolutely. And it's funny, when I started learning about cryptocurrency, what I saw as the person who was involved with it was exactly like Lauren's friend, somebody, I'm assuming he's kind of a young guy into coding, or somebody, if they're older, was very, technical. Maybe, they learned coding back in the 80s or the 90s, someone who was very tech savvy from almost a back of the house type thing. What was interesting for me in my practice is my first clients were older people. They were seniors who had heard about this cool thing, and they bought in because they were looking to grow their retirements. And so it was very, very different from what I expected. But I have seen a little bit of everybody in terms of socioeconomically, racially, culturally, geographically. It is something that a lot of people have heard of and are excited about and getting into. I mean, while there are people who are using it as an alternative to the dollar, because there are folks, Lauren mentioned a lot about how when you have something called fiat currency, which you can also define, is, dollars are government issued, government regulated, very much there's a hand in that process, whereas the technology is at least the idea is that the technology is what drives the digital assets in the cryptocurrency space. But my experience and from what my practice is like is most people are not looking to it as an alternative to the dollar. What they're looking to it to do is basically be like buying Apple stock at $10 in 2008. They are looking for an investment that they hold and it'll hit big. And as with any kind of investment idea, you're going to also have the people who trade on inexperience, naivete, and just generally are bad people who are looking for the next big thing to commit fraud in. I mean, I think for as long as money or assets have been traded, there is probably a schemer trying to figure out a way to part a kind and honest person from their assets. A lot of people think of it because it's so big. I mean, you look at a Coinbase, for example, and how many millions of trades they have, or a Binance, and then billions of dollars. And they think, oh, it's like the New York Stock Exchange. It's like Bank of America. And it's not. It's similar, but not the same. And so what their expectations about what happens when things go wrong are often not met because they are not those traditional institutions. And what is fascinating and terrifying to me is the ways in which people are approached by scammers. I've seen it on house hunting sites, people going to a real estate web, or someone pretending to be a person buying a house, and a realtor will then call them and say, hey, I see that you're interested in this property. And they say, yes, I'm a high net worth individual. I live out of state, da, 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 da. And next thing you know, this person is talking about their cryptocurrency investment and how the realtor can get involved. And you see it on professional networking sites and social media hobbyist groups where you think everybody knows everybody, and there's a scammer in there who also is going to the events and pretending to be one of the people, or just having a picture that makes it look like they're involved. Dating sites are another place where people have become targeted. I mean, essentially anywhere where there have been in a world where we do a lot of transactions where we never meet the people, there are opportunities for these fraudsters to essentially entice someone with a fake investment, give them something that looks much like what you'd see on CNBC, and then once they've got the money, they vanish. And because it's cryptocurrency, it's very hard to trace. A lot of the money goes overseas. There are a number of places where the government's, it's sort of in a third space where it's not exactly, it's, crime syndicates are sort of running things, and, folks are, in boiler rooms being trafficked. I mean, it's a sad story, but what is also terrifying about it is this is, that's where a lot of the money goes. And it makes it very hard for law enforcement because it's international crime, not simply something that's happening down the street or next door. So, I think there's a lot of great things happening, but there are a lot of traps for folks who don't quite, who again are expecting it to be a lot like what they're used to with a Merrill Lynch, and instead of it being a different kind of space.
Great, thank you so much, Candace. I would like to talk now about the FTX case. That's one of the more high-profile crypto cases. I believe both of you have been involved in some form or fashion of the litigation of that case. Lauren, maybe we can start with you. If you can kind of tell us kind of how the FTX case, maybe like the rise and fall of FTX, and also what's going on behind the scenes on the litigation side. How are we handling this?
Yeah, absolutely. And I will say that Candace and I both are, actively involved in this case that's being litigated and currently going through briefings and oral arguments right now. But I will talk about FTX as it's known throughout the news and throughout what has transpired over the last couple of years. FTX was one of the largest crypto exchanges to have the fall that it did as far as a wipeout of investor money. There were certain things at play with the individuals that were the, I'll call them FTX insiders, because that's how they are described in the litigation, the individuals that really started this company, which really operated out of the Bahamas, but also had a great deal of ties to Miami here in Florida. We saw last week that SBF, as he's called, Sam Bankman-Fried, he was sentenced, which we knew was coming as far as, you know, what Candace and I deal with, which is the civil side of this litigation. There's also criminal elements to there being, you know, nefarious activity as far as dealing with investments and dealing with fiduciary duties as far as customer funds. We saw that SBF was sentenced to 25 years, which was less than what was asked for by those who were prosecuting him. They had wanted 40 to 50 years. His attorneys were arguing for 5 or 6 years. So, you know, I don't know if that number is indicative of, you know, it depends on the certain evidence that went before them as far as, you know, what they considered an appropriate punishment for the actions that he took. This was a company where there were investors that were just so broad reaching. I mean, you know, everyone from the head coaches of NFL teams, you know, to figures that are around the world in countries that, you know, weren't even, you know, connected necessarily to a lot of the individuals who were really the ones that started this company. As you know, the arena in Miami where the Miami Heat play, it's the FTX arena, and FTX signed an $117 million lease for those naming rights. There was times when SBF, you know, represented that they could be in a position to purchase Goldman Sachs. You know, this is large scale money that they're dealing with. I mean, you know, some people are kind of like, oh, cryptocurrency, like tokens or whatnot. You know, at one point, this company is valued at $32 billion. And that's, you know, not made up money. That's not fake money. That's what, you know, companies are looking at this from a, you know, what is this company that's in the S&P 500 worth? What is this cryptocurrency exchange worth? And, you know, people were putting real money into this business. And that is, you know, where Candace information about, you know, the pitfalls of technology. You know, we live in a world where, you know, we have these wirehouse institutions that have things that are in place so that we understand how to cash a check on our phone, or we understand how to go in a bank and take money out of that. You know, 150 years ago, you know, before we really even had the technology we do today, you know, that didn't even exist. So now we're at a place where we have this new world of technology. You know, we're used to the old world of technology. And because we're in this 21st century where, you know, the World Wide Web has really just revolutionized things. I mean, we're just launching into areas that we never, ever expected to be in. And we'll continue to do so, I anticipate, with the way AI is going to shape not only cryptocurrency, but just the way that our work, you know, the way that we work as humans in all different types of industries across the country. FTX, it'll be interesting to see how this plays out in the courts. You know, there's a lot of different individuals involved. I represent a media defendant, which, you know, was a party that was involved in some of the advertisements that were created regarding FTX, you know, advertising campaigns. We know that there was a lot of celebrity individuals who were involved in FTX, YouTuber individuals who were involved in promoting FTX. And, you know, all of these individuals, by virtue of the ties to FTX, have been pulled into this litigation, which is pending in the Southern District of Miami. You know, it's going to be some time to see how this plays out. While often criminal litigation moves, or criminal cases move, you know, fairly quickly based on the way our laws work, civil cases take time. And we'll just have to see exactly how all the different all the different facets of this case work out, because there really are, you know, there's 3 different avenues that we're traveling down. You know, we're traveling down what is the criminal side of things that we saw play out last week. We're traveling down the recovery of assets, you know, trying to track down money to return money to defrauded investors, which is part of what I do in another side of my practice, receivership work, you know, work where you take charge of a company, where there's a federal appointed equity receiver who is making sure that he marshals assets to the individuals who, were defrauded of those assets by virtue of the company's operation. And there's the civil side, the who's really at fault. Obviously there were individuals who suffered extreme losses here. There was large scale money that was wiped off the map. Like, where does the liability lie if it does truly lie with the individuals that, have been hailed into court? So we'll have to see. Candace is on the flip side of the coin as far as the litigation. So I'll let her touch a little bit on her stance and her clients and just what she sees as far as FTX, even if it's outside the litigation and just about the company generally.
Absolutely. And, you're speaking to me, my language, because I did a lot of receivership work and asset recovery. And so watching where did it go and can we get it back is something that I have an interest in, just generally because of FTX, but also professionally because that is something that I do and have done. I represent a group of folks who used FTX, and one of the things Lauren was mentioning, the naming rights, the celebrities, the YouTubers, the folks that we have brought suit against are investors. Because the names, some of the names out there are pretty big names, and there used to be a commercial back in the day when so and so speaks, people listen. And one of the things that I think that we will have to see about is, what is at what point is being involved reach something where you're more than just an investor. You're somebody who is like the social media influencer, helping to influence people to get on the platform. We'll see where things go. There are so many different parties and so many aspects of what everyone did in what, if Sam Bankman-Fried is the spoke, there were a lot of, or the hub, there were so many spokes of the wheel. And it will be interesting to see what happens with regard to those spokes. And one of the things, I guess, when I look at this, it's a story about cryptocurrency, but really it could have been a story about a movie studio or some other industry, because at the end of the day, what Sam Bankman-Fried was accused of and convicted for is garden variety fraud and theft. Problems with corporate controls, not having separation between one company and another company, not having the proper kind of board and accounting and practices and those things. Those are things that are garden variety stuff that really cryptocurrency is the background story to something that has happened over and over again. The examiner who was involved with Enron. I was at a firm that was very much involved working with him back in the day when Enron came along, and it had similar problems, although he says this is worse than Enron. But the bottom line is, every so often there is something like this that comes along, and it's just, sometimes it's a new industry, sometimes it's a new way of looking at an industry. There was something called mark to market, which haunts me in my dreams, but that was the thing back then. So there's always going to be someone who sees something new and fresh and finds a way to do the old things. And I think that's something to remember about cryptocurrency and a lot of our new technologies, is that delivery systems may be different, but people have been using some form of currency since there were people to trade something. And the problems that are attendant to those are probably as old as, somebody exchanging a leaf for a rock, back in the day. So that's something important to remember for people who feel intimidated by the spaces. Oh, all these things are, it's like, this is, put on your thinking cap and think about it like you'd think about, if you were making an investment and, and if you were buying a new house and you didn't know a lot about about buying houses. What would you do? Same kind of thing. So it shouldn't be scary, but you also need to be smart.
And that's just
Perfect.
one part about cryptocurrency too, that, that there's, the smartest of the smart, and then there's people that are just, a drop in the bucket, looking at this technology. So, the difficulty, at least with FTX and what has been acknowledged by those who are involved in the marshaling of assets, I think was the lack of corporate controls. I mean, at the center of things, you have a business dealing with just, such a large scale of funds, and just not having, that established understanding of running this business that really made it so that it was going to fail, among other things, in just SBF's involvement.
Great. Thank you both so much for that. Yeah. Now I'd like to move on to focusing more about the future of crypto, where we're heading next. Obviously we've seen the downfall of FTX. There's things we need to learn. There's challenges we need to address. Lauren, maybe you could start, and then we'll pass the microphone to Candace. And if you can kind of tell us where you see crypto going in the future.
Yeah, absolutely. And I think that a lot of where crypto will go in the future, at least on the legal side, will depend on the regulations. We very much are in a space right now where the regulations haven't caught up. They haven't addressed many issues that are playing out now in the courts that will affect how the technology is treated in the future. I think that as far as cryptocurrency as a whole, that the issues that have been experienced, whether it be FTX or whether it be, some of the bankruptcies that we've seen of other crypto exchanges here in the United States, I don't think that it's going to make it so cryptocurrency absolutely goes away. I mean, we saw within the last month or two, that Bitcoin is on the rise. There's some countries that have put their whole stakes in this. I mean, El Salvador, they took Bitcoin as their national currency. And, while there might be certain people that have adopted cryptocurrency in such a large scale that walk that back, there's enough people who are dedicated to this, and institutions and law firms, and just widespread support that's going to make it so that, this may be more regulated, it may be treated differently. It may have to play out in the courts in certain regards as to failures that have been experienced, but that it's going to continue. And I think a lot of that comes down to, the element of trust, that people want to give something that's validated by a system network of validators. We have obviously an economy that is run by supply and demand. What Candace said, someone traded a rock for, for food back in the day. And that bartering was the first, exchange of goods, and then transitioned into what we now know in our, technological society is currency, and that's something that it'll be interesting to see how cryptocurrency, translates into that. Because once again, cryptocurrency is a little different from fiat currency, like Candace talked about, in that you can have a store of value and you can also have a payment system. And that's very foreign, and that's very hard to conceptualize for those of us who, use $1 or $5, $6 to buy our coffee in the morning. It's not as user-friendly right now to use Bitcoin to buy a coffee at the local coffee shop. That being said, you can use Bitcoin to buy Tesla. And there are businesses that are making it so that you can spend your cryptocurrency easier. I think that the way that blockchain, that technology contributes to society makes it so that cryptocurrency is going to continue. I mean, the fact that, you have a technology that regulates how many Bitcoins can be mined and brought into circulation just by the smart transactions. I mean, that's just something that you couldn't conceptualize without being Satoshi Nakamoto and the creator of Bitcoin. That's not something that, like, we as people that aren't, developing this or a part of this, it's foreign to us. But it's interesting because, when you look at it from an economical standpoint, like look at diamonds, the diamond industry in the United States, people want to buy diamonds, to represent, love, marriage, Valentine's Day. It's something that is a selling point as far as a stone. It doesn't mean it's any different from a ruby or an opal, but it's valued higher by our society. And a lot of that is that, back in the day, De Beers and other diamond companies, they made it so that diamonds didn't flood the market. They held them back. They controlled the actual mining of these diamonds to make it so that our economy, had a demand for a product that wasn't, flooded by having too much of it. Well, here, we don't have a regulator. We have blockchain. We have a technology that's going to make it so that this currency won't come into existence until, I think, 120 years from now. I mean, not all of them will end up coming into it because of the way it's mined, but the majority of it will be here. We will all be long gone. But, that's just so interesting that you can have a technology that slowly creates this trickle of this, technology through the validation process into society. I mean, that's something that isn't heard of from, a standpoint of the fact that we have governments that create currency. We have currency that's backed by certain things, like how money used to be backed by gold. But a technology creating something like that, I think that there will be a way for it to continue. And I mean, look at the failure of other currencies in other countries. That it just takes one, absolute failure of just severe inflation to make someone think, hey, maybe 100, 200, 300 years from now, there's going to be something different that's not going to be, subject to this type of control.
Great, thank you so much, Lauren. Candace, would you like to say a few things about the future of crypto?
Sure. And I just want to back up a little bit. When Lauren mentioned that 150 years ago we didn't have the same technology for moving money, I'd like to put a plug in for the Gen Xers who it was actually the 90s. It was the 90s when we did not have that. I mean, and I say that in part to say that this is all happening in a fairly compressed time period. We are still in the very, while it's been, maybe 20 years at this point, it's still very new. And I say that to say, I think it's hard to predict what's going to happen. We'll have to see. I don't think anyone anticipated when, there were the phones that were this big that we would have the ones we have now, or how we use them for everything but making phone calls. So I think this may be something that could look very different. It may be a situation like other industries where you wind up with, you have all these many players, but you really wind up with having maybe Bitcoin and Ethereum and maybe a few others, and it winds up operating more like traditional currency than the way it does now. There are 180 currencies, I think, circulating worldwide. As Lauren mentioned, there are, tens of thousands of cryptocurrencies, and it, from a sustainability standpoint, I don't know how long or how well that will last, particularly given that you have things like a hot cryptocurrency 1 year that platforms won't even support 3 years later. I think the marketplace, people will lose an appetite for something they can't trade. And that they don't know if they ever will, or when they will be able to. And, for the same reason, there are a lot of junk and scam tokens. I mentioned, I think about, there was a Squid Game token a couple of years ago that everybody got excited about because there was the buzz about the movie, and it was gaming, or so people thought, and it was just a scam. And I think people's tolerance for that kind of thing, and their, I think, desire for someone to do something is going to it may cause some of this to at least to mutate a little bit, so that it isn't quite as much of a wild west. But I also think that, for as new and as different it is, as I said before, with regard to the act of some form of currency, there are a lot of things this looks like. Going back to last week, there was an SEC, there was a an order in the case between the SEC and Coinbase. And the thing that the judge said was, and I quote, "The crypto terminology may be relatively new, but the transactions in question fit within an established framework courts have used to classify securities for nearly 80 years. And so, you know, in that, at least in that instance, with regard to certain cryptocurrency or certain cryptocurrency transactions, courts are looking at it like securities because that's something that it can be analogized to. So I think there's going to be a lot more looking at things that we have and treating them accordingly. But one of the things, probably one of the things that I really hope for is that there is more and better education of law enforcement, of legislators and the public, because I think for there really to be a future with cryptocurrency, there need to be four things: stability, predictability, safety, and consistency. And while some of those sound the same, really what that means is if I say I want to buy a token, I can feel safe. I can feel like it's real. I can put it somewhere. That somewhere will be safe too. I can transact with it or hold it for investment. But those things happen without me having to think, well, let me only put a penny into it because it's going to go whoosh, or the company is, you know, you've got a Zhao or a Quant Luna or, you know, an SBF, and I can't trust it. In order for it to thrive, it's got to be trustworthy. And I think the pillars of the public, legislators, and regulators and law enforcement, getting to better understand it and create some rules of the road is how we move forward.
Great. Thank you so much for those insights, Candace. I have one more question for you both today, and then we're going to wrap it up. What's going to happen with the FTX case?
Oh man, I think I'll let Candace answer this one.
I think my clients are going to win. I mean, I can't predict the future, but I choose to believe that that's what's going to happen with FTX. Lauren, I have a feeling you feel the same.
I think I might take the other flip of the coin, but we'll let the Southern District play it out.
Absolutely, and I look forward to seeing you down there sometime.
Yeah, I'm sure it will be sooner rather than later. Well, thank you, Will. We appreciate your time today, and we're happy to answer any questions that come through. And my information online, Lauren Humphries, if you just Google Tampa, I'm always happy to email back and forth if you have any questions or if there's something that piqued your interest and you want to talk more about it. I think, you know, the more that we have legal interest or non-legal interest in this, it once again adds to the space. Knowledge is power in certain regards. And I think that having an understanding of this technology or even just talking about it sometimes can add to what people know.
Absolutely. And I'm here, Candace Smith. If you Google Candace Smith Atlanta lawyer, you'll find me. I'm the only one.
Great. Well, thank you so much, Lauren. Thank you so much, Candace. With that, we're done. I'll pass it back to Jerry. Thank you so much for tuning in.
Thanks.
Thanks, Jerry.
Thank you so much, Candace, Lauren, and Will, for that great presentation on the latest crypto cases. I want to thank everyone for joining our webinar today, and I hope to see you all in person at the conference on May 6th in New York City. Thanks and have a great day.